Okay, hello, and welcome to the second part of this bar preparation lecture. And for those of you that have been sitting on pins and needles and are curious about the ancient Greek, I will go ahead and translate it for you, and maybe you can already read it, but it says, Tis tebios ti deterpnan ate cruces Aphrodites. And that's one of my favorite lines from the ancient archaic Greek poet Memnermus. And it means, what is life, what is pleasure without a golden Aphrodite? Classic Greek poetry. Okay, so we've talked about the different parties that are involved in secured transactions and the different types of collateral. Now what I want to do is kind of take a step back and talk about what it takes to create a security interest so that you're able to identify whether a party is truly a secured party or a party that doesn't have any security interest at all. And then also whether a secured party is a perfected secured party or an unperfected secured party. So I want to talk about the creation of a security interest, which is called attachment, and also the perfection of a security interest. And then we'll talk about priority rules and then spend a few minutes on that other flavor of secured transaction question that deals with the enforcement of a security interest. So here we go. Attachment. What is required to create a security interest? Simple, 3 elements, and if you put these down in your one-page essay, it will impress the graders. 3 elements required for attachment are that value is given, that the debtor has rights and collateral, and that there is a authenticated security agreement. Go through them again. That value has been given. And that's typically not controversial. That means that a loan has been given by the bank, or something has been sold on credit by the seller. Value has been given to the debtor, in other words. So that's usually pretty straightforward. The debtor has rights in the collateral is the second element. This is in 9203 of the UCC. Debtor has rights in the collateral. Of course, that's intuitive. You're not going to create a security interest in something that you don't own, that you don't have any rights in. The third element is the one that's most heavily tested, and it is the one that's the trickiest. And that is that there is an authenticated security agreement in place. And really, it doesn't require much. A security agreement can be a one-line contract that says that the debtor hereby grants a security interest in favor of the creditor in the following assets. And there has to be a proper description of the assets. And that's one thing that can be tested, that the assets are properly described. There can't be a super generic description of the assets, as I've mentioned in the first part of my lecture. You can't say that the debtor hereby grants a security interest to the creditor in all debtor's assets and property. It has to be more specific than that. How specific does it have to be, though? That's the question. And here's the rule. That it has to reasonably identify the collateral so that the courts can figure out what is subject to the security interest and what isn't, and the parties can understand. It has to reasonably identify the collateral. It doesn't have to be specific, doesn't have to state by serial number every item that's subject to the security interest. It just has to reasonably identify it so that parties know what is and what is not subject to the security interest. But the safe haven that's provided, and I think it's 9208 off the top of my head. But the safe haven that is provided for the description of collateral is to describe collateral by the categories listed in the UCC. And that is goods, or instruments, or inventory, or equipment, or money, or deposit accounts, or general intangibles, any of those types of collateral that are described in the UCC. Then you're safe. Then you're fine. If you say the debtor has granted a security interest in all of debtor's goods, then that's fine. All of debtor's goods, it's clear. Everything that is movable property is subject to the security interest. Or all of debtor's inventory, that's fine. All of debtor's deposit accounts, that's fine. If you want to be more specific, you can be, but that's the safe haven. Okay, well, let's move on to perfection. Well, let me say one more thing about attachment, is that there are certain scenarios in which you do not need an authenticated, that is a signed, security agreement, where an oral security agreement will be sufficient. And when is that? When the creditor has a possessory security interest, that is when the creditor actually takes possession of the collateral. Maybe the collateral is a valuable stamp collection, and the bank takes possession of it and puts it in its vault. Then an oral security agreement is sufficient. There has to be still some understanding orally, some meeting of the minds, but you don't have to have a written security agreement. And also when there is control over the collateral. For example, when you have control over a deposit account, or control over investment property, which is another type of collateral that includes stocks and bonds. So, well, let's move on to perfection. So, the first thing to know about perfection is that first you need attachment. Perfection by itself, that is, for example, the filing of a financing statement, will not create a security interest. You always have to have attachment. You always have to have those three elements of attachment in place to have a security interest. And then the question is the secured party perfected? In addition to having attached a security interest, is it perfected? And so you need to have attachment, and then you need to have another step in place that results in perfection. And that typically, 99% of the time, will be the filing of a financing statement, which is this one-page document that you file with the Secretary of State in the state where the debtor is located. Okay? There are other types of perfection, and this is again where the type of collateral can come into play. For example, you can perfect by possession if you're dealing with collateral that are goods, right? Tangible, movable property. Or if it's instruments, like a promissory note, you can hold a promissory note. Or chattel paper, right? Remember the sales installment agreement coupled with the security interest? If you hold that contract, you have possession. Money, yes, again, if you have possession, you've got it. Documents, that is, title instruments. Again, possession will suffice for perfection. So you should know those types. There are 5 types, but typically what will come into play in a bar exam is you have goods, maybe a mint coat or a stamp collection, or could be inventory or equipment that the creditor takes possession of and is thereby perfected. Other types of perfection include control. Now, I'll give you one example, and that's deposit accounts. You can only perfect a security interest in deposit accounts through control. And there are 3 types of control for deposit accounts. One is that you have a control agreement with the bank, saying that if there's default, the bank has to pay the money in the bank account over to the creditor. So there can be a control agreement. The bank that has a security interest is the bank that actually holds the bank account, that is the maintaining bank. That's another way to get control, right? Has a security interest in an account that the bank itself has. That's a type of control. And the third type of control is that the creditor becomes a customer on the account. That is, actually has its name added to the account, so it has the power to withdraw money. That's another type of control. So those are 3 types of methods of getting control for deposit accounts. And control also comes into play with investment property, but that's getting a little far afield. You know, I think that if you understand possession and control with respect to deposit accounts, you're going to be in pretty good shape. Some types of collateral allow for automatic perfection. You don't have to do anything. And the most important type is a purchase money security interest in consumer goods. So let's say I go to Best Buy and I buy a widescreen TV on credit, and Best Buy sells it to me on credit and takes a security interest in it, so that if I default, it can come and repossess my widescreen TV. That's a purchase money secured party, Best Buy, right? Because they've sold something on credit and taken a security interest in that very thing. It's a purchase money security interest in consumer goods, because I'm buying that for my own personal use. It's automatically perfected. Best Buy doesn't have to do anything. Doesn't have to file a financing statement, which it typically would have to do. Okay, so those are the basic elements of perfection. Some of the things that are tested on the bar exam are, for example, whether the financing statement is sufficient. And you should remember, just like you remember the 3 elements of attachment, remember the 3 required elements of sufficient financing statement: the name of the debtor, the name of the secured party, and a sufficient description of the collateral. And here the standard in the description of the collateral, it's a little lower than a security agreement. And here's one good rule to take with you into the examination hall, that super generic descriptions are permitted in a financing statement. That's okay. If you have a super generic description in a security agreement, it blows it up. There's no security interest. But if you have one in a financing statement, it's okay. So if you have a security agreement that says there's a security interest in all debtors' inventory, and then a financing statement that says there's a security interest in all debtors' property, that's fine. It perfects the security interest in that inventory. It doesn't create a security interest in anything else just because it says all property. The scope of the security interest is always controlled by the security agreement. All right, so that sets the limits. The financing statement may be broader by saying all assets, and that's okay, because that puts any other creditors on notice that there may be a security interest in the debtor's assets. Another thing that's frequently tested is the name of the debtor, because you have to have the name of the debtor, name of the secured party, description of the collateral. The name of the debtor, the question is, how close does it have to be? Does it have to be the exact legal name of the debtor? That is, imagine that the debtor's name is Sunshine International Incorporated. What if the financing statement in the space where the field where it says name of debtor just has Sunshine INT-L International, and then they file it? Is that enough? Or does it have to say Sunshine International Incorporated? Or can it say Sunshine International Inc.? That's the question. And this is the answer that you have to put down. If that is flagged as an issue, this is the standard that you have to put down in your answer. That the name of the debtor is sufficient if the financing statement will be turned up under the search logic of the Secretary of State's office. So if you run a search under the legal name of the Secretary of the debtor in the Secretary of State's office, if it turns up this financing statement, then you're fine. So if the debtor's name is sufficient to turn up the financing statement under the standard search logic of the Secretary of State's office, then you're okay, as long as it comes up, because that's all you want to do, is that so when someone searches under the true legal name, Sunshine International Incorporated, that this the computer system will turn up this financing statement. If it doesn't, because you've messed up the name so much, then it's not sufficient. Then the financing statement is treated as if it's not filed and you're not perfected. So that's the issue. And typically, if you leave out words like Inc. or Incorporated, those are noise words, it'll still turn up. But you should probably put Sunshine International, spell it out. If you leave out Incorporated, probably be okay. The search logic of the Secretary of State's offices aren't that strict. For the secured party, there's really no standard at all. You're supposed to have the name of the secured party, but the UCC says that no error will be seriously misleading. And that's the standard. And also for the debtor's name, it can't be seriously misleading. If the search engine logic doesn't turn it up, it's treated as seriously misleading. So seriously misleading is the core standard for both of them. But then when you break it down for the debtor's name, it's whether the search logic will turn up the financing statement. For the secured party's name, It's never seriously misleading. So you could put down Donald Duck, theoretically, and it should be okay. Okay, so those are the three elements for the financing statement. The other thing that's frequently tested is that you file in the right place. You've got to have a sufficient financing statement with those three elements, and then you've got to file in the right place. And what's the right place to file? In the location of the debtor. And where is the debtor located? You're only going to file in one place, wherever the debtor is located, and that's the big question. And here's the answer. And this is, people don't know this. They have trouble with the bar exam, but I'm going to help you out with the answer here. Where is the debtor located? It's not that difficult. If it's a registered organization, that is, if you have to file something to create the organization, if it's a corporation, if it's an LLC, if it's a limited partnership, you got to file something to create those entities. You got to file certificates of organization or certificates of incorporation. If it's a registered organization, corporation, LLC, LP, then it's located where you file the organizing documents. So if it's a Delaware corporation, because you created the corporation in Delaware, that's where you file your financing statement if you're the creditor. It doesn't matter if it's an Ohio company located in Ohio, operating only in Ohio. If it's incorporated in Delaware, you file in Delaware. And that's a classic question in the bar, because they're going to give you a fact pattern where it says it's headquartered in Ohio and they do all their business in Ohio and they're incorporated in Delaware, and then the creditor files a financing statement in Ohio. And you are going to know that that financing statement is invalid. It's as if there was no filing and the party is unperfected. And you have an unperfected secured party. Okay? So if it's a registered organization, then you file in the place of where it was organized. If it's just a regular organization, it's not registered, which is a general partnership, right? A general partnership. You go into business with someone, you open up a lemonade stand with your best friend, and you don't file any paperwork. Under the operation of law, a general partnership emerges. And then where's that general partnership located? It's located where the headquarters are, or where the principal place of business is. And it's wherever your lemonade stand is. Okay, so that's a general partnership. What about a sole proprietorship? That is, I have a lemonade stand of my own. I didn't go into business with anyone. But I want to take out a loan and secure it on all the assets of my lemonade stand. Where does the bank file its financing statement to perfect its security interest? It's a sole proprietorship. It files where I am domiciled, where my residence is. So this is a typical question that may come up on the bar examination, is that someone has a lemonade stand and they live on the border of Pennsylvania and Ohio, and the lemonade stand is located across the border in Ohio, but the owner lives in Pennsylvania. And where should the bank file? It should file in Pennsylvania, where the owner is domiciled, not where the business is carried out. So if you know that, you're good with those questions, and that's frequently tested. So no registered organization, file where organized, general partnership, file where headquarters is, where the principal place of business is, sole proprietorship, file where the owner is domiciled. Okay, I think we're doing pretty well here. Let's get to some priority rules. So now you've identified the parties, whether they are a secured party, that is, whether the security interest is actually attached. You've identified whether they're a perfected secured party. You know if they're a buyer, or whether they're a buyer in the ordinary course of business. You know if they're a lien creditor. You know if they're a purchase money secured party. You're able to identify that. And now the question, once you've identified that, is simply to apply the priority rules for those parties. It's that easy. Once you've figured out what type of parties you have, And then you just apply the priority rules and you know who wins. So let's just go through 7 priority rules and you'll be in good shape. First, let's say you have a secured party, someone that has an attached security interest, against someone who is unattached, didn't have a security interest because they didn't have a proper description of the collateral, let's say, in their security agreement. Thought that they attached, but in fact didn't. So you have a secured party versus an unsecured party. Who wins? The secured party, of course. Okay. That's rule number 1. Secured party defeats an unsecured party. Okay, now let's say you have a perfected secured party versus an unperfected secured party. Okay? Because one filed their financing statement in the right place, and the other didn't, or didn't file a financing statement at all, or didn't have the sufficient description of the debtor's name. So if you have a perfected secured party versus an unperfected secured party, who wins? Easy. The perfected secured party. That's rule number 2. Now let's say you have a contest between 2 perfected secured parties. They both did everything right, both filed their financing statements that were sufficient and in the right place. Who wins? This is an important rule to know, probably the most important priority rule. The first to file or perfect. The first to file or perfect. It's not necessarily always the first to file. It may be the first to perfect, because you may have someone that perfected by possession, and then another secured party later on perfected by filing a financing statement. It's the party that perfected first by possession will win, because it's the first to file or perfect. Let's say someone, if you have 2 that filed, perfected by filing, whoever filed first wins. Now, consider this, that someone, a bank is in negotiations to give a loan and files a financing statement, and then the debtor goes to another bank, negotiates to get a loan, they file a financing statement later on, and they give the money, they give the loans, they give value, and they enter into a security agreement, so they attach, and then after that, the first bank decides to give a loan and enter a security agreement, and so attaches. So now the first bank that filed a financing statement first actually attached later on, right? They gave value and entered a security agreement later on. Who wins? Here it's the first to file, that first bank. Even though they gave the loan, they attached later, first to file wins. So it's always good to get your financing statement filed first. And then you can take your time giving the loan and entering into the other agreements. First to file will win. First to file or perfect. What about a lien creditor versus a secured party? Right? You have someone that, right, I ran over that person's bicycle and they got a judgment against me, I didn't pay, and they converted into a writ of execution, and now they're coming after my assets. But I also have a bank that wants to get at my table, my fancy table here. So we have a secured party versus a lien creditor. Who wins? The secured party will win as long as it was perfected before the lien creditor arose. That is, as long as that bank filed a financing statement, it will win. As long as it was before that lien creditor tried to seize my table. Okay, so in a contest between a secured party and a lien creditor, secured party wins if it's perfected before the lien creditor arises. And that goes for the trustee in bankruptcy as well. As long as you're perfected before the bankruptcy occurs, you can reach through that stay of actions and get at the assets that you had a perfected security interest in. Okay. How about a buyer? Secured party versus a buyer. So this is when the bank, remember, has a security interest in that lathe that's owned by a company, but then the company sells it to another machine company. And now the first company goes bankrupt, and now the bank wants that lathe, but the buyer wants to keep that lathe. Who wins? And the answer is that the bank will get it as long as it was perfected before the purchase. The bank will also get it if the buyer knew of the security interest, even if it was unperfected. So the bank will win either if it was perfected before the sale, or if the buyer really knew of the security interest, that is, had true knowledge of it. What about a biocob, the buyer in the ordinary course of business? Buyer in the ordinary course of business always wins, will always defeat any secured party. You know that. When you go into Walmart to buy your lawnmower, you're going to take it home, and no bank is ever going to come after you. Buyer in the ordinary course of interest always takes free of any security interest created by the buyer's seller. That's the rule. It's a mouthful. But what it means in short is that the buyer in the ordinary course of business always wins. There's a bit of a nuance there in that you only take free of the security interest created by your seller, by Walmart. And if the security interest was created by some other party prior to Walmart getting in control of the goods, that's another question, but again, we're getting a little far afield. Finally, the purchase money security interest versus another secured party. Purchase money secured party has super priority and will win. As long as it does certain things, as long as it files its financing statement within 20 days of the debtor getting delivery of the collateral. That's what it has to do when you're dealing with equipment. As long as the purchase money secured party files a financing statement within 20 days of the debtor getting delivery of the equipment, it will have super priority and will defeat any secured party, even if there's a bank that filed a financing statement 2 years before. Purchase money secured party wins. When you're dealing with inventory, there's a bit more of a complex rule that in order to get that super priority, the purchase money secured party has to be perfected upon delivery, that is, prior to delivery. And the secured party also has to give notice to every secured party that has a financing statement on file against the inventory. So it has to give written notice to everyone before the inventory is delivered, and has to be perfected by filing a financing statement before the inventory is delivered. So if for inventory, purchase money secured party has to do those two things. Not just get the financing statement in within 20 days of delivery, but has to be perfected before delivery and has to notify any other secured parties that have a financing statement on file before delivery. And then, purchase money secured party and inventory will get super priority over any other secured party, even if they were perfected long ago. Those are the 7 rules, priority rules. If you got those down, believe me, you're good. There's a lot more to secured transactions, but if you get these basics down, you're going to pass the question. I have 2 more minutes left in my hour, and that's enough to really focus your mind on the important issues in the second flavor of question that may come up with respect to secured transactions, and that is the enforcement of a security interest. All right, upon default, if you don't make your loan to the bank, if you don't make the payment to the bank, it has the right to enforce its security interest. It has the right to repossess your collateral and then sell it. What are the issues to keep in mind when you're answering those types of questions? There are 2 things I want you to keep in mind. One is with respect to repossession. You cannot breach the peace when repossessing collateral. So you might have a scenario where there's an automobile that's to be repossessed. The repo man cannot threaten violence, cannot commit violence, cannot use a gun, cannot do anything that will likely escalate into violence. That's the policy behind it. So the question is, has there been a breach of the peace? It's okay to maybe trick someone, pretend you're a valet driver and take their keys and then drive off in their car. It's okay to, without their consent, to sneak up and jimmy the lock and get into the car and drive off into the night. It's okay to go in the middle of the night if it's in their driveway. One thing to keep in mind is you can't open any doors. You can't open any lock, even if they're unlocked. You can't open up a closed garage door. If the car is in the garage and the garage door is open, you can hook up a tow truck and take it. That's fine. But you can't open any doors. You can't walk into a business, even if the doors are swinging. You can't walk into a business and take inventory off the shelves. That's breach of the peace. If the doors are open, you can. If a gate's open on a ranch, you can walk in and take the combine or other equipment, but you can't breach the peace. So that's something to keep in mind. And the other thing is when you're selling the collateral. So you've repossessed it, and that's fine, and now you need to sell it. And the creditor keeps the proceeds and gives any surplus back to the debtor or other junior creditors. And then the question is the sale proper? And this is the standard of the law, is that every aspect of the sale must be commercially reasonable. And that's the basic bottom line. And typically that means that you carry out a public auction and you properly advertise it. You don't just take this car and you put it out. If the debtor owes you $1,000, you take a Ferrari and put it out on the street with a sign that says $1,000, first to offer gets the car. That's not commercially reasonable. The Ferrari's worth $100,000. You're going to take that car and auction it at a fine car auction. You're going to do what's commercially reasonable. And here's the safe harbor, is that it's commercially reasonable if you follow the procedures for selling something that are followed by the dealers in goods of that kind. Okay? As long as you sell something the way that a typical car dealer in Ferrari sells things, then you're fine. So just remember that you have to be commercially reasonable in every respect when you sell things. I'm going to leave it at that. I can't cover everything, but I hope this has helped. If you have any questions, feel free to email me or drop by my office. I'm usually in, and I'm glad to talk to you about secure transactions anytime. Good luck on the bar exam. I hope we pass 100% this time for the first time in Cleveland Marshall history, and I wish you the best of luck.